occurs at no cost to the governments that often adopt them. And I thank the gentleman
Will
for
the gentleman
yielding.
yield for a question? Would the gentleman yield for a question before yielding back? Mr. Issa?
Sir, of course, I'd love to hear it.
Mr. Fitzgerald.
I beg your pardon. Mr. Fitzgerald, thank you. Then maybe the question goes to Mr. Issa. Does this statute respond to some new case? That's one, does it overrule some significant decision in law that would, because I know this has been an issue for a long time. For example, as a lawyer earlier in my career, I can remember that there was litigation like Westlaw is the big, now it wasn't even electronic at the time. Well, it was, but they would publish law, and then there were cases over whether that could be copyrighted. And then they said the editorial enhancements could be, but not the law. Is there some new decision that this overrules?
There are a number of cases, and of course they vary from state to state, where there's copy and paste going on, where these SDOs are litigating, sometimes winning, sometimes losing, and we'd like to create a single predictable standard for both sides. So yes, there have been a number of them, and of course they're occurring at the state level, and we want to have a harmonized one because it is our responsibility. I appreciate the gentleman. I thank the gentleman from Wisconsin for yielding to both of us. Yield back.
Mr. Gentleman's time has expired. The gentlelady from California is recognized.
Move to strike the last word.
Gentlelady is recognized.
I strongly object to this bill. It runs counter to longstanding Supreme Court precedent that recognizes that all citizens should have free access to the content of the law, and it also poses, I think, serious constitutional concerns that have recently been noted by the U.S. Court of Appeals for the District of Columbia Circuit, permitting private ownership of standards that are essential to understanding one's legal obligations. I'd like to ask unanimous consent to put into the record an article, "Bill in Congress would bar Americans from deciding our own laws."
Objection.
Starting with the case of Wheaton versus Peters in 1834, when the Supreme Court decided that no one could copyright a court decision, there's a long line of decisions that you can't copyright the law itself. Most recently, in a case in the D.C. Circuit, American Society for Testing versus Public Resources Organization, they said this: a serious constitutional concern with permitting private ownership of standards essentials to understanding legal obligations. As a matter of common sense, access to the law cannot be conditioned on the consent of a private party. That was confirmed by the Supreme Court when Justice Roberts affirmed, saying no one can own the law. Now, this bill would overturn those legal decisions that are recent ones, barring citizens from reading, and I would say also disseminating laws without a license is completely contrary to our concept of law, where citizens own the law that we make, not some private entity. Now, I understand that the chairman thinks that this has been satisfactorily resolved by allowing people to view a web page. That is insufficient. If we want robust debate, and in order to do that, for people to argue about standards, you have to be able to disseminate them, to argue about them, to critique them, not just to a view only. And I would note also that some of these standard organizations, having been pressed by the courts to make this information available, are now doing it, allowing it only if you give up your private information, you register with them, you give them their data. Never in the history of this country have we required citizens to give up their personal data in order to look at, understand, and argue about the law. This is a complete departure from the history that we have in our proud country. I would note, and I would ask unanimous consent, that the amicus brief that I wrote and filed with the District of Columbia Circuit Court be made a part of this record. In that brief, I note that our own laws, our Open Government Data Act, requires not only that it be open, but that it be shareable, that it be machine readable, so that the citizens can have complete access to government information. And I think that standard that we have placed to all federal agencies about information should not be denied people seeking access to the laws that are incorporated by reference. I would ask unanimous consent that we
Would the gentlelady
Not right
mention
now.
who wrote that brief?
I submitted the brief with the help, as we always get, from outside lawyers. In this case, Jeff Perlman, the Intellectual Property and Technology Law Clinic from the USC Gould School of Law. I would note that we won this case, that the law is free today. This bill, which I wish we'd had a hearing about it because I could have made my objections known at that time, this overturns not only the recent win for freedom, for access to the law, but it is contrary to the entire history of the United States that allows citizens access to the law, to own it, to disseminate it, to argue about it, and by giving the ownership of the law to a private party, it's completely contrary. But going back to my unanimous consent request, it's a letter sent by the Electronic Frontier Foundation, Public Citizen, Public Knowledge, Demand Progress, the Internet Archive, Library Futures, the Authors Alliance, and several others, with a memorandum outlining the serious problems with this bill. I see my time has expired, so I will yield back, but I have a series of amendments that I will offer to try and fix this.
Gentlelady's time has expired. The gentleman from, I think the order was Mr. Bishop from North Carolina.
Thank you, Mr. Chairman. I hope to ask a series of questions. And I will tell you that coming to this hearing on this markup on this bill, I've been troubled because I've had some advice to be concerned about it. I'm familiar with it from my own legal practice over time, but I'm not an expert on the law that Ms. Lofgren cites, and I want to make sure I understand it completely. I'll also say I tend to be sort of in the middle of the road on this. I do think standard-setting organizations ought to be able to operate as they do to formulate standards. Those ought to be able to be incorporated into law. There ought to be reasonable access to them for people who are not practitioners. But it has always been true that there are editorial enhancements and sophisticated functionality in Lexis and Westlaw as examples that can be copyrighted even though the law cannot.
Correct.
And I think the question is what is the right level of access? And so I'm taken in part by Ms. Lofgren's argument just now, but I'm not sure what constitutes going too far. It seems to me, and perhaps I'll ask the gentlelady, or yield to the gentlelady in a second if I can formulate this to see what the problem is in her view. But what if the information is available on a website? And again, the problem I have is the one I've just happened to pick out is International Codes Council. They've got it set up so that you, and frankly, the costs, I will say, are quite modest to get a subscription even to their further access. But you can go and look at it. It seems like you ought to be able to function like a normal web page, ought to be able to take, cut and paste information from it, ought to be able to do a basic search. But, more advanced stuff, if there are annotations of cases, if there's editorial content like headnote systems that we're familiar with from legal cases, all of that ought to be copyrighted, it seems, copyrightable. And it provides a value for people to have an incentive to produce it. For the purpose of advancement of whatever the art in question is. So I'd yield to the gentlelady from California if she would care to speak on that a moment. I'm trying to get better clarity.
I thank you. I thank the gentleman for yielding. Yes, these standard-setting organizations, many of them produce manuals that help people comply with it. That's copyrightable. That's not the law. That's it's similar to LexisNexis. I mean, you can't copyright the decisions, but you can copyright the critique of the decisions, or it's the same thing. The problem here is that you go to a website, let's say you're a civil libertarian and you disagree with part of building standards. You should be able to copy that, to publish it, to have discussions with others of like mind about that. You can't limit debate and understanding
But
of
if
the law.
I'm trying to narrow it.
I
If you
understand.
could, I mean, if I can give a link to the website where the whole code can be read, how is it better to copy it and distribute it?
Well, we've never allowed a private party to own the law.
I understand
And-
the issue, the basic issue there. Let me ask. My colleague from North Carolina is sort of shaking her head. So see all the dissension on the Democratic side I can create. I'd just like to yield to the gentlelady from North Carolina to see if she could get at what I'm trying to ask.
So first of all, I want to express
kidding,
my great respect for my colleague, Representative Lofgren. She is a brilliant legal mind, and I hate to ever disagree with her.
I don't
But-
mind that.